We left off last time talking about the Supreme Court wanting to maybe hear from the Cherokees again, or somebody maybe related to them. So that gets us up to Worcester v. Georgia. Tell us what happened with this, and who is Samuel Worcester, and what business is it of his?
Yeah, Samuel Worcester and a guy we forget called Eliezer Butler were New England missionaries working in Cherokee Nation. Worcester was actually the postmaster, so he was there as a federal employee.
He's a federal guy.
Yeah.
This is significant.
Well, it should have been, but it doesn't seem to have been. It wasn't necessary for the resolution of the lawsuit that he got involved in. Worcester failed to obtain a license from Georgia as required by Georgia law to be in the Cherokee Nation. He and Butler were apprehended.
And they're asking for an oath of allegiance to Georgia's government, and Worcester says, I don't want to do that.
Yeah, they're not interested in supporting the governor of Georgia. So they get hauled away, sentenced to a term of years in Georgia prison at hard labor. They request judicial relief from the Supreme Court of the United States, Worcester and Butler versus Georgia, shortened to Worcester versus Georgia. In 1832, John Marshall takes the case and basically will conclude by saying, let those people go. Now, that's interesting. What's more interesting is the reason that Georgia has to let them go in the view of the Supreme Court of the United States.
Right. What's that reason?
Well, there are two parts to it. One of them, the one that we remember best, and it's the easiest to apprehend, is there's a long section at the end of the opinion in which Marshall says, for the majority of the court, Georgia can't enforce its laws because it has no jurisdiction to impose its laws over the Cherokee Nation, including those under which Worcester was prosecuted. And they have no jurisdiction because, and as I say, this is part of the holding, we've got a treaty with the Cherokee Nation, and the treaty contemplates continuing Cherokee self-governance, and Georgia's abolition of Cherokee laws and imposition of Georgia laws conflicts with the promise in that treaty. So under the U.S. Constitution, under the Supremacy Clause, if you've got a conflict between a state statute and a federal treaty, the federal treaty wins.
Right.
And so that's fairly straightforward. So that's the Supremacy Clause portion of the holding. And as I say, that's what's best remembered. Less well remembered, but I think far more interesting, is the rewriting of Johnson versus McIntosh that the court does.
Okay, what's he doing there?
Well, you remember that, that Georgia's grounds for believing that it had jurisdiction to impose its laws over Cherokee Nation was its position that under the discovery doctrine it owned the land. Georgia was the landlord, so we can change the lease terms. That was a problem that Marshall had created, and now it was time for Marshall to fix it. So in Johnson, the historical predicate, right, the basis for that was this history that had been sort of cut and pasted from Marshall's Volume 1 and John Marshall's Life of George Washington, that led, he said in Johnson, inexorably to the conclusion that the British had considered that they, or understood that they owned the title to the land. In Worcester versus Georgia, there's not a single citation to Johnson versus McIntosh. There's no overt overruling of that portion of Johnson versus McIntosh. What there is a complete rewrite of that historical section. And it begins something like, on the discovery of North America, there were folks living here, and so charters were granted. What was the legal effect of those charters? And the answer to that question, Marshall says in Worcester, is the charters and international law, by implication at the time, gave the British Crown the exclusive right to purchase, and no more. And that's a quote.
And no more.
And no more. It's an erasure of that vesting of ownership, vesting of fee title portion. It's a retention of that restriction on alienation, that you can only sell whatever you got to the U.S. But no longer did the British own, under this new formulation of the discovery doctrine, title to indigenous lands, which means no longer did Georgia have any claim to own the title to the lands of the Cherokee Nation, which meant that they had no basis at all under Supreme Court or any other law for asserting their jurisdiction over the Cherokee Nation. So that the treaty the Supremacy Clause business was helpful, but this rewriting the Discovery Doctrine was a message to all those other states out there, and Tennessee had passed this law,
Yes.
and Alabama or Mississippi had passed this law, and the message to them was, it doesn't matter if there's a federal treaty with the tribes that you're attempting to assert jurisdiction over. You have no power to assert your jurisdiction over these tribes because you don't own their land.
And he also claimed at the same time that the indigenous nations were nations and retained some rights.
Well, yes, and that's language in Cherokee Nation versus Georgia. It's understood in Worcester versus Georgia. The effect of Worcester versus Georgia, I think, was meant to be it's a rewrite of Johnson. It's a new sort of way of looking at indigenous rights. Indigenous peoples are self-governing. They're immune from jurisdiction exercised by the states within whose territorial limits they may happen to find themselves. Their relationships are meant to be exclusively with the federal government. It's a very clear sort of what we call black letter way of looking at indigenous rights. They're comprehensive, they're expansive, and they're immune from state interference.
But is it still the case that the doctrine of discovery pertains in many cases? So,
well, two things happened after the Worcester decision was handed down, because that vision didn't turn out to have staying power.
Okay.
And it's partly due to demographics and partly due to politics. Demographics were the most important element. You know, the Supreme Court justices don't live forever. Marshall himself was soon to die. Members of his court started leaving, and their places were filled by the incumbent president, who, of course, was Andrew Jackson. These new justices, by the late 1830s, occupied a majority of the seats on the Supreme Court. Jacksonian justices, one appointed by Martin Van Buren, who was Jackson's chosen successor. And these guys took the opportunity in half a dozen cases decided between 1835 and 1842 to reintroduce that original formulation of the Johnson discovery rule.
Okay.
And
so you can kind of pick and choose among your precedents, is that right?
well, you can, yeah. And this, again, wasn't done overtly. This is, a couple, was a case dealing with the New Jersey riverbed, a couple were Florida land claims. But they all provided opportunity for the court to say, oh, and by the way, as everyone knows, when Europeans arrived, they acquired ownership of the underlying title to Indian lands.
Okay.
And so completely rewritten, and so sort of, and this was also a problem with Worcester, because Marshall never expressly overrules Johnson versus McIntosh for political reasons. It's very subtle what's happened, and so subtle, in fact, that with the overwriting of these subsequent cases, I think we just forgot for years this political battle that went on, which is really the story of the book. This brief shining moment in which there was a different world for Indian peoples, and that it was a reversal of that earlier. Lawyers and legal historians, I think, have tended to try and reconcile them. Well, they aren't reconcilable, the Worcester and Johnson rules, because one overrules the other, and that was, I think, the intent.
It sounds like a good intent.
Well, yeah, and but the politics, the Cherokees did remove, right, as did the Choctaws and Chickasaws, et cetera.
Even though Marshall decided that Georgia's imposition of its laws was unconstitutional.
Right.
But what happened there?
Well, Jackson declined to accept the opinion in Worcester. This is the point at which Andrew Jackson supposedly maybe said something like, John Marshall's made his decision, now let him enforce it. Supreme Court doesn't have much in the way of enforcement power. They don't have an army. They don't have, and Georgia had said, we're not gonna let those missionaries go. Jackson started sending agents out to meet with the 5 southeastern tribes to reassure them that Johnson was good law, that Worcester was bad law, and that they were gonna have to go, or they were gonna be subject to state law. And then the demography on the court, the retirement and death of justices started to make this likelier and likelier.
Let me return to that key point, that the executive branch just declines to enforce a ruling of the judicial branch.
Here's what happened over the summer. The opinion's issued in the spring in Worcester versus Georgia. But the Supreme Court doesn't issue what's called a mandate, which is a direct order to the state to let the missionaries go. That won't happen until, because the court goes on recess until the court reconvenes in the fall. Mm-hmm. And so there's a little time, right? Georgia can let these guys go, and then there won't be a constitutional showdown, right? Which might require the court to call on the president for assistance to make Georgia obey. There's a little breathing space. South Carolina decides to go crazy that summer and fill the breathing space with a convention called, the idea is Jackson supporting states' rights. Now is the time to take a stand against the federal tariff, which is a different story outside the scope of this course. Mm-hmm. South Carolina had been mad for years about Congress taxing imports because they import practically everything. Right. So South Carolina says, and they didn't think the federal tariff was constitutional. So in that summer, after the Worcester decision's handed down, South Carolina meets in convention, and they pass something called the Nullification Ordinance that says that if a state believes that a federal statute like the tariff is unconstitutional, they don't have to enforce it. Mm-hmm. Now, this is too much for Jackson, who recognizes that this is the end of the Union.
And he's willing to go to bat over the South Carolina case, but not over the Cherokee case.
Well, South Carolina changes his thinking about the Cherokee case. And Jackson recognizes that if states can decline to enforce federal law, then there is no union anymore. Right. So Jackson sends a note to the governor of Georgia and says, you let those missionaries go. This is a bigger problem than just the Cherokees now. Mm-hmm. And then he gets Congress to pass something called the Force Bill, which would have authorized him to send the Army into South Carolina. South Carolina repeals the Nullification Ordinance. Mm-hmm. And the governor of Georgia, the day before the Supreme Court reconvenes, when they would have had to issue this mandate, lets these two missionaries go. And the crisis is diffused.
Okay. Well, let me ask you about a hypothetical. Let's say, for instance, that Georgia had not decided to release the two missionaries. What sort of enforcement mechanism is in place? What does Worcester v. Georgia reveal about the system of checks and balances and the lack of enforcement with the Supreme Court? Should this case come up again, what prevents the executive branch from ignoring a ruling of the judicial branch?
Well, those are two different questions. The court has much more institutional gravitas now. It's hard to imagine the executive ignoring a Supreme Court decision anymore. Mm-hmm. So that's almost too hypothetical to question. But even assuming that it did happen, there is more available to the court in terms of enforcement opportunities now than then. I see. But back then, the Supreme Court was a real vulnerable institution. They were out to a certain extent in uncharted territory. It wasn't until 1803 that the Supreme Court claimed the power to invalidate federal statutes as being unconstitutional in Marbury versus Madison. Right. And the executive response was to impeach one of the Supreme Court justices, right, for different cause. But it so shook the court that John Marshall, who had done this sort of tentatively in Marbury versus Madison, never again invalidated a federal statute. Really? And it didn't happen again for 50 years. That's how shaken the court was and how nervous about exercising this power. Now we take it for granted. Mm-hmm. Right. I don't know what mechanisms would have been available to the court in 1832. There's been a lot of some legal historical literature on that. What would the court have done? And it's not clear that the court was sure what it would do. There's correspondence from the justices, Justice Story to Justice Marshall, saying, if they're going to abolish the court or take away our jurisdiction, and there was legislation proposing maybe the Senate should sit in review of Supreme Court constitutional law decisions and that sort of thing. But Justice Story writes, I wish they'd go ahead and abolish it now while I can go back home to Massachusetts and practice law. I'm young enough to get some clients. Mm-hmm. I don't think they had a plan B. I think they just stuck their necks out and said, let's see what happens.